Andrew Dawson, Puja Parikh, and Melissa Cornell.
Thanks so much, Amy, and thanks everybody for joining us. So we wanted to put together a presentation. I know in the past, I think the firm has done similar presentations. We wanted to broaden it a little bit this year. Obviously, being where we are in San Francisco, and the nature of our clients and the work here, privacy, data security, cybersecurity are obviously front of mind for a lot of people. And it's, as Amy mentioned, kind of constantly shifting landscape. So we're hoping to kind of walk through a little bit of kind of different angles on the issue, in a sense, walking kind of chronologically through it, and hopefully give a helpful overview of kind of the landscape of claims, regulatory authority, and then also how things can go wrong, and sort of some illustrations of what that might look like, and steps to take in advance to prevent that from happening. So to start, I think if we can move to the next screen. Here we are. So we first, just with introductions. So I have not met many of you on the Zoom. I'm relatively new back to the firm. So I was a summer associate here a long time ago, and then an associate. But I was in the U.S. Attorney's Office for about 9 years, and I returned to the firm in September. So I'm thrilled to be back. I'm thrilled to be kind of part of the community again. That's sort of where I grew up. And one thing that I did in the U.S. Attorney's Office for a long time was cybersecurity, kind of hacking cases, computer intrusion cases, including some things that relate on data privacy. So I would admit up front that my knowledge base is somewhat narrow, but in that range, it's relatively deep. I've done a lot of that work on the criminal side. So obviously my expertise comes in kind of towards where things go wrong. And so I think that's mostly what I'll be focusing on. But obviously, I also wanted to turn over to Puja and Melissa, two of our extraordinary colleagues, to introduce themselves as well.
Hi, all. I'm Puja Parikh. I have been with Kecker for about 6 years now. I am going to be talking about the regulatory landscape and its changing nature, particularly under the Trump administration. So I look forward to having that conversation and kind of seeing where that goes. In terms of my practice here at Kecker, I've covered a wide array of different matters, from general civil commercial matters to mostly focusing in on the IP side of things, both hard IP with patent cases and then soft IP cases, trade secrets, copyrights, things like that. But as you all probably know, we kind of do it all over here. And so I'm happy to turn it over now to Melissa to introduce herself, who's also run the gamut in the terms of work that she does.
I think you're muted, Melissa.
Thank you. Hi, everyone. My name is Melissa Cornell. I'm excited to be with all of you this morning. I got to the firm right around the same time that Puja did, and my work also runs the gamut, including intellectual property disputes, as well as privacy disputes. I'm currently working on a privacy matter with some colleagues here at the firm. And I've also done a number of investigations, both on the civil side and the criminal side, including an internal investigation. And of course, as I'm sure many of you know, and oftentimes those investigations will implicate privacy issues.
All right, so we can move to the agenda. I think most of you may have there we go. Okay. Apologies in advance for our tech struggles. So just to run through very quickly to give the overview, but not spend too much time. I think Melissa's going to start with the privacy landscape, some of the developments, the causes of action, the kind of legal vulnerabilities for folks to be aware of. Puja is going to focus on the regulatory environment. There are more and more action, more and more agencies, entities, both at the state and the federal level, that are paying attention to this area. And there's a ton of, I think, public support behind some of those initiatives, but it's creating a lot of uncertainty. And obviously, the Trump administration is the big gorilla in the room, which is upsetting and kind of scrambling a lot of expectations. And then my focus, as I mentioned, is a case study that I think is an illustration of how things can go terribly wrong and when they can go terribly wrong. And hopefully, as we work through that, we can talk a little bit about steps to take and off-ramps to a path like that to ensure, obviously, that nothing like that would happen again. So it's a case I handled primarily in the U.S. Attorney's Office, United States versus Sullivan, which is, so far as I know, the one instance in which a cybersecurity breach resulted in criminal liability for an executive. In the case, the trial was a few years ago, but it was just affirmed by the Ninth Circuit a couple weeks ago. So it seemed like a timely thing to be addressing. And there's sort of a not exactly parallel, but sort of thematically parallel SEC matter called Solar Winds, which at the end, if we have time, we'll get into that a little bit as well, since it has a somewhat similar fact pattern, did not lead to any criminal exposure, but has been a long-running SEC matter now, and we can address that at a high level as well. So with that, I'll turn it over to Melissa to start with the privacy landscape.
Okay. Okay. So when we say the term privacy, that can refer to an array of issues, causes of action, regulatory agencies, enforcement. We can be talking about privacy at the constitutional level. We can be talking about it at the statutory, congressional level, state level, and of course our regulatory agencies. This 1-hour presentation isn't going to cover all of that, of course. So this is to sort of focus us a little bit and talk about the various causes of action that are out there that are most common for privacy. Some of these do have a long history, but we are seeing these causes of action being alleged, as Amy had mentioned earlier, every single day against our clients. And the ways in which that they are evolving based on the way that clients are changing their business models is a really interesting phenomenon that we're excited to talk about today. So the first big category of causes of action and law that privacy really touches on are these common law invasions of privacy. You can think about, these are sort of your classic like 1L torts, intrusion upon seclusion, misappropriation of name or likeness. And these torts are certainly not new by any means. But what's interesting about these kinds of torts is even though many states have broad and old swaths of case law, these torts are now being alleged in new ways, and the case law is certainly, and the decisional law is certainly developing. So I think misappropriation of name or likeness is a really interesting one. I think the classic case of this kind of tort is often brought by a celebrity saying that, a brand or a company has taken their likeness or their name and they're using it for profit in a way that they're doing it without consent. They're doing it sometimes without even notice. Now we're seeing these torts being alleged against companies and clients that are internet companies that are doing a service where they're kind of in like a white pages or yellow pages type way, but in an online fashion, collecting information about people. Sometimes it's in a general way, sometimes it's more specific based on industry, and creating these databases that can be then offered sometimes for free, sometimes for sale to customers who are in need of it. And misappropriation of name or likeness has been a tort that's been alleged companies in this kind of way for this type of action. And while there are certainly strong defenses against this kind of tort, including First Amendment defenses, a lot of these claims are not reaching the highest courts. And so a lot of this law is still unsettled, even though the torts themselves are actually quite old. Then we're also seeing the other kind of section of present, current, timely privacy law falls into this consumer remedies category, which many of this may not be strictly privacy, but the laws are being applied in a way to address privacy issues. And so under this category, we have things like unfair competition law and a lot of privacy actions where we're sort of seeing a mix of torts and statutory claims. We also see those unfair competition law claims get thrown in. Then, of course, we have our state statutes, and we're going to talk a lot about that today, including the California Invasion of Privacy Act, which has been around for decades. And new statutes are on the books or are in the works and are going to be on the books very soon, including the California Consumer Privacy Act of 2018, which was effective in 2020. And these consumer privacy statutes are really becoming a focus for legislatures all around the country at the state level and also at the federal level. And they're really becoming strong vehicles for regulators. And Puja is going to talk a little bit more about that in her section. And then we have the federal statutes, and here's just a few examples of these. Of course, at the federal level, we don't have kind of a far-reaching privacy regime. There's certainly been theories that potentially there are rights to privacy embedded in our Constitution. Certainly, like the Fourth Amendment would be an example of that, but we don't have these big privacy statutes. We have these sort of small, narrow, focusy privacy related statutes like the Wiretap Act, the Stored Communications Act, that create a very narrow set of obligations, but can still be difficult for companies and our clients to grapple with and to understand, especially as their businesses are changing and the way that their use of data is changing. So the interesting phenomenon that we're seeing at the state level is that in the absence of this big federal statutory regime, states are really taking it upon themselves to fill the gap. The story really that doesn't start necessarily, but I think that's very interesting with the California Consumer Privacy Act of 2018, which became effective in 2020. This came on the heels of the European Union's GDPR, which is a massive privacy regime over there in the European Union, but that affects our clients here in the US if they are reaching users and consumers in the European Union. And since the CCPA was passed, we are seeing a lot of other states either create copycat laws or they are taking a look at what California did and starting with the same premise of wanting to create more rigid protections for consumers when it comes to their data and creating their own sets of laws. So these laws are kind of, we saw a ton of them being passed in 2024, going into effect in 2026. And, with every week that passes, we're seeing more states kind of focus in on consumer privacy and data privacy. The federal government at the congressional level is also interested in protecting consumer data. We have seen a number of attempts to have privacy and consumer data play more of a role at the federal level. This law is an example of that, that had a lot of momentum a couple of years ago, but has sort of stalled at this point under the new administration. I bring it up because it is a bill that did have strong bipartisan support and was actually being sponsored by a Republican Congresswoman, Kathy McMorris Rogers. So while it's sort of, gathering dust at the moment, that might not always be true in the future. So this presentation is going to focus a lot on the California Consumer Privacy Act. Puja is going to talk a little bit more about that, but just to sort of set the stage for that, the CCPA really is a first of its kind consumer privacy law that is providing protections for consumer data like we've never seen before. The CCPA is often compared to the European Union's GDPR. This is more of sort of like an academic intellectual side, so I won't spend too much time on it, but it is kind of interesting when we look at what the European Union has done and what California has done, and just kind of the different approaches. The GDPR approaches it much more of Data privacy is an inherent right, whereas California is more focused on, I think, like righting past wrongs and protecting consumers. I think one of the biggest differences is the GDPR actually requires opt-in consent for companies to use consumer data, whereas under the California model, it's an opt-out model. And we're going to skip ahead a little bit just for the sake of time. Obviously a quick flag for the CCPA, because you might be wondering, does this apply to me? It applies for-profit businesses in California affecting California residents, but there's also a number of other criteria. And so this is something to keep in mind as you're thinking about your own compliance obligations. But also something that, as companies evolve, as their use of data changes, compliance obligations and the application of these statutes, will also change. The statute is relatively new, and so we're seeing seeing enforcement kind of happen before our eyes. The first big enforcement action resulting in the settlement against Sephora happened just a couple of years ago in 2022, where there was an investigation into the privacy practices of Sephora and how they were and permitting third parties actually to use it as well. There were a number of allegations, but the focus was the CCPA. Sephora decided to settle. It resulted in 1.2 million in fines, but probably the more costly part of the settlement, and the thing that is, I think, was the most burdensome for Sephora and will be the most burdensome for companies like it, was this compliance program that was set up as a result of the settlement and the number of reporting requirements that the Attorney General's office imposed. The last thing that I just wanted to focus on is this fear of data breach, because I imagine for any company out there who is handling consumer data, this is the fear, of course, what happens in the event of a data breach. And now with AI, with the reliance of consumer data, it really has started to become a question of when this happens, not if. I'm sure many of you, like me, we receive these notices of data breach in the mail all the time for products that we're not even really thinking of. I think I got one a couple weeks for the company where I bought my kids' car seats. And so this is really something that is going to affect businesses both at the big data, the big tech level, but also at a smaller level as well. And when it comes to these data breaches, Andrew obviously is going to talk more about what happens when when the response goes wrong. But when thinking about what you can do on the front end, it really is about preparation, as with many things in life. Understanding both how your data is used, but also having that incident response plan in place so that if that data breach occurs, you will already be in crisis mode. That's going to be the default, but you can hopefully be in a position where you are responding in a timely way so that you know which regulators you have to respond to when, and you are meeting those reporting deadlines. And with that, I will pass it off to Puja.
Thank you so much, Melissa. I would like to talk a little bit about U.S. privacy regulatory, the scheme over the last few years from 2023 or so to the present, and then touch on what the Trump administration has already implemented and what we expect the Trump administration to implement to the extent that we can predict it. Sorry, pardon the tech here. So I'm just going to pick up on the thread that Melissa discussed earlier without rehashing it, which is what we've seen recently is the rise of state engagement in ensuring comprehensive privacy regulations. And some would argue this is due somewhat in part to congressional failures to come up with a comprehensive privacy legislation. The bottom line is, regardless of what the underlying cause is, by 2026, about 20 states, which comprise half of the US population, will be covered by a comprehensive state privacy law. And this is just 7 years after California enacted the CCPA, so it's been very rapid. So in this slide, you'll see that we're referring to these privacy laws as robust or comprehensive. What this means is that these laws share the same basic requirements of providing consumers with rights to access, correct, and delete their personal data, and provide consumers with rights to opt out of targeted advertising, profiling, and the sale of personal data. So the recent wave of state privacy legislation shows most states are converging on core obligations. There are, however, some meaningful divides on specific issues that are emerging and are important to note. And I'll give you some examples. For example, all state privacy laws to date, with the exception of California, grant enforcement authority solely to the state attorney general. 3 states, California, Colorado, and New Jersey, have empowered state agencies to issue regulations related to the respective privacy laws. And there are various definitions among the state laws, which does mean that there are going to be some differences. For example, consumer opt-outs, and there's differences in what qualifies as a sale of personal information or data. Moreover, since the Children's Online Privacy Protection Act, or COPPA, was enacted in 1998, state privacy law has generally considered children's data to be sensitive data, subject to the COPPA rules requirement that businesses must obtain parental consent before collecting personal information from children under the age of 13. But in recent years, states have expanded youth privacy protection to include heightened opt-in consent requirements for teenagers under the age of 16, by requiring businesses to get affirmative consent for targeted advertising or sale of data. So as an example, New Jersey and Minnesota have extended the opt-in requirement to those under 17, Delaware extends it to age 18, and Maryland goes further than any other state by prohibiting targeted advertising and the sale of data entirely if a business knew or should have known that the individual is under the age of 18. So we can see that there are some variations among state privacy laws that do require careful consideration, particularly for certain industries. We'll focus a little bit on California, which is where I'll head next. So in 2024, the California Privacy Protection Agency, or CIPA, began to take a more active role in privacy regulation and enforcement. It published the first of its 2 California Consumer Privacy Act enforcement advisories, addressing 2 different things: the application of data minimization to consumer requests and the avoidance of dark patterns. So these are hefty words. I can break it down a little bit. Dark patterns are user interfaces or architectures that have the substantial effect of subverting or impairing a consumer's autonomy, decision-making, or choice. Deploying these sorts of user interfaces is a privacy-averse practice pursuant to the CCPA. Along with these enforcement advisories, the CCPA and the California Attorney General have issued confidential notices of violations to certain companies that include but are not limited to the scope of these enforcement advisories. The CCPA also provides a limited private right of action, which allows consumers, individually and as a class, to pursue civil litigation when their personal information falls subject to the unauthorized access and exfiltration, theft, or disclosure as a result of the business's violations of the duty to implement and maintain reasonable security procedures and practices. That is a mouthful. In practice, this private right of action is used almost exclusively to address data breaches. So there wasn't really any significant movement in 2024 on this particular issue, But it is interesting to note that some courts have issued rulings that do support an expansive interpretation of what constitutes a data breach that is subject to this private right of action. It's also interesting to note that though the CPPA has begun privacy enforcement in California, the California Attorney General continues to play an active role in enforcing the CCPA. In January of 2024, the California Attorney General announced an investigative sweep focused on streaming services. The California Attorney General also announced 2 settlement agreements under the CCPA in 2024. The first was with a major tech company, and it addressed the CCPA's requirement that a business disclose and provide consumers the right to opt out of the selling or sharing of their personal information. The settlement agreement itself is comprised of a pretty low settlement penalty, all things considered, and injunctive terms that reiterate existing requirements of the law, but notably do not require changes to the business practice. The second settlement resolved claims that a mobile gaming company violated the CCPA and COPA by failing to obtain parental consent for collecting and sharing children's data from a mobile app. It resulted in a $500,000 civil penalty and a settlement agreement that requires the company to obtain consent for processing children and teen personal information, providing just-in-time notice when children's data is sold or shared, and properly configuring third-party software development kits to comply with children's data legal requirements. Finally, in September of 2024, California enacted its Protecting Our Kids from Social Media Addiction Act. The law prohibits operators of what it deems addictive internet-based services or applications from providing what it calls addictive feeds to minors, unless the operator does not have actual knowledge that the user is a minor or otherwise obtains parental consent. The law also prohibits these operators from sending notifications to minor users between certain hours, and it requires an annual disclosure of the number of minor users of its service or app. What's the most notable about this is that this law was blocked from enforcement earlier this year in 2025, with the trial court concluding that the law is likely an unconstitutional restriction on protected speech. As of January 28th of 2025, the Ninth Circuit has granted a permanent injunction against the law's enforcement pending appeal. So for now, there's no real actionable consequences as a result of the law, but we'll have to see where that lands following the appeal. I know we've spent a little bit of time on the states and California, but there's also some things going on in the congressional legislation and executive action realm that we should discuss. And I'll start with the Biden administration's most recent positions and then move into where we are under the Trump administration. So in March of 2023, the Biden administration released its national cybersecurity strategy, which came in the wake of some significant cyber intrusions and ransomware attacks, like Solar Winds, Microsoft Exchange, Colonial Pipeline, JBS Foods, some of which Andrew is going to talk about later in this presentation. So the Biden administration's strategy includes integrating federal cybersecurity centers, modernizing federal defenses, and increasing the speed and scale of intelligence sharing and victim notification. These are lofty goals, but to that end, the strategy really has embraced the need for greater regulation of the private sector. In April of 2024, President Biden signed H.R. 815 into law, which includes the Protecting Americans' Data from Foreign Adversaries Act. The law, which went into effect midway through 2024, prohibits data brokers from selling, transferring, or disclosing personally identifiable sensitive data of a U.S. individual to any foreign adversary country, China, Russia, Iran, North Korea, or any entity controlled by a foreign adversary country. Finally, in January of 2025, days before he left office, Then President Biden issued an executive order to further secure federal agencies and contractors and give the federal government more power to sanction the hackers who target critical infrastructure. So to accomplish this executive order calls for these robust attestation requirements for software providers. For instance, software vendors who sell to the government will have to prove that they're using secure development practices to win and to keep these federal contracts. The executive order has also endowed the U.S. Cybersecurity and Infrastructure Security Agency, CISA, with significant responsibilities, including a central role in validating these attestations and coordinating an agency's attacks to cyber defenses. We'll talk about how under the Trump administration, CISA's role has now been severely limited. Before we get there, though, I want to touch on a few other agencies who play a pretty vital role in the regulatory environment. If I can get there. Okay. So I'll start off with the Federal Trade Commission, which, folks generally know. They have asserted that data security falls under their Section 5 authority to police unfair and deceptive practices. In recent enforcement actions, the FTC has treated privacy and cybersecurity as coextensive. So what this means is if the FTC opens a privacy or consumer fraud investigation, then the commission will also look at the respondent's data security and practices, or vice versa. If it opens a matter based on a data security issue, it's going to examine the company's privacy practices. In December of 2024, the FTC filed a complaint against an AI and deep learning-based video analytics and video cloud software company, alleging the company made false, misleading, or unsubstantiated claims that its AI-powered facial recognition software was free of gender or racial bias, and that it had one of the highest accuracy rates on the market. The complaint alleged the company didn't train its facial recognition technology on millions of faces as advertised, but really instead trained the technology on approximately 100 individuals. The final order against the company prohibits the company from misrepresenting the accuracy of its technology without competent and reliable testing of the technology to support its claims, among other restrictions and requirements. In January of this year, the FTC finalized changes to COPPA, that's the Children's Online Privacy Protection Act we talked about earlier. It includes a variety of different changes, including an opt-in parental consent requirement to disclose children's personal information to third-party companies for targeted advertising, limits on data retention, where a covered operator should only retain personal information for as long as reasonably necessary, public disclosure requirements, and several amended definitions, including expanding what qualifies as personal information to include biometric identifiers and government-issued identifiers. So that kind of marks where the FTC was when we're talking about January of 2025. For the SEC, 2024 marked the first full year of its new cybersecurity disclosure rules for public companies, requiring disclosure of material cyber incidents. Approximately 50 public companies did file these cybersecurity disclosures, but many were for non-material impacts. Actually, about 20% of the filings state a material impact. 2024 also marked historic levels of enforcement activities by the SEC. Notably, with the exception of Solar Winds that Andrew is going to discuss later, all of the SEC's recent cybersecurity disclosure cases involved company-only settlements where the SEC demanded that the company determine that the companies had reason to know material information about a cybersecurity incident but failed to escalate that information to the individuals within the company that were making disclosure decisions. And so this is really interesting to take a look at. The next one is too, I promise, but this one is interesting to take a look at. It's worldwide privacy enforcement actions and not just the US regulatory scheme. But it's interesting to see how that has rocketed following 2018 through, you can take this graph through 2024. But then, of course, we have the Trump administration. This administration has taken a different perspective on cybersecurity and privacy regulation. The administration is not entirely hands-off on cybersecurity, but has definitely changed to a narrowed focus. And I'll give some examples of this. So for instance, the SEC recently announced the creation of a Cyber and Emerging Technologies Unit, C2, that will focus on fraudulent conduct in cybersecurity, digital assets like cryptocurrency, and emerging technologies such as AI. There are a bunch of different priority areas, but they're kind of lumped into these sorts of categories. So for public companies, this announcement of this new role of C2 indicates that the unit is going to focus on combating fraud and other cyber-related misconduct, but it's going to take a step back from some of the more aggressive enforcement actions brought during the Biden administration by focusing on these sorts of cybersecurity, digital assets like cryptocurrency, and AI tech. Some experts do predict that the SEC's announced priorities signal this narrowed focus and will also result in cases where the conduct has to rise to a higher level of misconduct before the SEC will take on the action. The Consumer Financial Protection Bureau has also been impacted under the Trump administration. And in fact, the Trump administration has imposed some significant operational changes that raise questions about the agency's future, scope, and direction. The administration has frozen virtually all CFPB activities by ordering employees to stop all enforcement and litigation activity. It's halted rulemakings and it's suspended effective dates of pending rules. DOJ has expressed a desire to completely eliminate the CFPB. What this means in practice is if the CFPB's activities are curtailed, other regulators may step up their enforcement actions. The FTC, which has concurrent enforcement authority with the CFPB over certain statutes, can police unfair practices under the FTC Act and has insight into the CFPB's investigations and enforcement under the agency's Memorandum of Understanding. State attorneys general also have broad authority to enforce the state consumer protection laws, but they can also enforce the Federal Consumer Financial Protection Act in their respective jurisdictions. State banking departments can enhance supervisory oversight over non-bank financial institutions, and private litigants can seize upon regulatory uncertainty to pursue consumer litigation. So there is a way to kind of do some gap filling over the role of the CFPB. Finally, there are some executive actions that are worth mentioning that do impact the regulatory environment. Just last week, President Trump directed White House senior security advisors to draw up a national resilience plan to protect critical infrastructure. So notably, the plan shifts more responsibilities to the state and local level. That's kind of the TLDR of it. Under the executive order, the Department of Homeland Security has made efforts to make CISA smaller by ending about $10 million in annual funding to the Center for Internet Security, about half of the funding. This is the latest move by the Trump administration to rein in the federal government's role in election security and countering misinformation. And CISA's funding cuts has followed on the heels of the Trump administration's move to disband an FBI task force focused on investigating foreign influence operations, including those that target US elections. Also, the Department of Homeland Security has cut about half of the federal funding to the Multi-State Information Sharing and Analysis Center, which shares intelligence among state-level cyber agencies and staff. The takeaway really from these executive actions is that the Trump administration is asking states to lead and take the charge on their own with limited federal assistance. So we're certainly going to see changes in the regulatory landscape under President Trump. There's no doubt about that. But there will be a continued emphasis, albeit somewhat narrowed, on cybersecurity and privacy regulations. And with that, I'll turn it over to Andrew to talk about some of the litigation that we've seen that's quite interesting.
All right, let me see if I can get my tech here to work. But one thing that's striking to me, having listened to the presentation here, the case that I am going to be focusing on, this Sullivan case, is remarkable for how many of those areas that Puja and Melissa just spoke about, how many of them overlap, intersect, and play a role in what ultimately became, I think, in a sense, a cautionary tale. It's a kind of worst case outcome for a cybersecurity operation, for a privacy operation, a worst case response to a data breach. But it's also something that I think illustrates how many steps could have been taken along the way, how many off-ramps there were to reach a better outcome. And in some ways, as we go through this, the breach in question happened in 2016. So it's a long time ago. It's 9 years ago. It's sort of the Stone Ages by comparison to where we are today in terms of where state privacy was. But I think the dynamics are similar. They're more intense now. There are more state statutes. There's more privacy scrutiny. But at the time, California had been an innovator in privacy issues. And a lot of the dynamics that we have seen play out over the last 9 years were present in a sort of early form in the Sullivan story, in the Uber story. And I think it's a good illustration that even today has become more intense, but even 9 years ago, these same issues were at play, the same risks were there. And I think the same off-ramps existed, the same considerations would have had a dramatic effect on how this played out. So the basic story, the kind of factual overview concerns a data breach that Uber suffered in 2016. If memory serves, something on the order of 60 million user records were stolen by a couple of hackers, one in Canada and one in Florida. And the resulting negotiations, they reached out to Uber to disclose in some fashion what they had found. And ultimately, they wanted a payoff. They wanted some benefit. And there was a series of back and forth. All of this was disclosed at trial. All of this is public. I obviously can't share anything that wasn't public that kind of goes behind the DOJ cloak, but so much has been litigated now that thankfully it's a sort of complete story, particularly with the Ninth Circuit. The data breach in 2016 wasn't the first data breach that Uber had ever suffered. There had been a previous one in 2014. And to get back to a little bit, I think it was Puja talking about the FTC and the FTC's views on cybersecurity and privacy and their overlapping nature. The 2014 breach at Uber resulted in exactly that kind of FTC investigation. Back then, the FTC was taking that position and was opening investigations. 2014 was relatively early in kind of Uber's existence. And it was, it's not uncommon, as many of you know, for in the early days of a fast growing kind of internet platform, that there isn't the same kind of infrastructure in a young growing company that there may be in a larger company. And it's not uncommon for the FTC to kind of leap on some publicized incident, some kind of data security, cybersecurity incident, and to open an investigation. And that's exactly what happened to Uber in 2014. The investigation in 2014 lasted for a good long time. At some point in the middle of that investigation, Uber hired Joe Sullivan, who remains today a very kind of respected professional cybersecurity expert who had come from Facebook, who had been previously at PayPal, had a lot of experience, and he was hired in a sense to kind of clean up the Data Privacy Act at Uber. The company was growing very quickly, was putting more resources behind its cybersecurity efforts. And along with many of those efforts, they wanted to bring in, as the trial kind of testimony and evidence reflected, wanted to bring in a real expert, A, to fix some problems, and B, to kind of show to the FTC and to the regulators more broadly that the company was very serious about cybersecurity, data privacy, and wanted to do things correctly. Now, it didn't turn out the way they were hoping. Ultimately, in 2022, there was a trial, and Mr. Sullivan was found guilty of obstruction of justice and misprision of a felony. And he was sentenced to a 3-year term of probation and ordered to pay a fine of $50,000. The conviction was affirmed by the Ninth Circuit, as I mentioned a couple of months ago. I anticipate it's not the end of the story. There will likely be further litigation. I wouldn't be surprised if there are en banc petitions. But I think regardless of what happens, the story ultimately, even if Mr. Sullivan were to prevail at the end, no company, no executive wants to go through what he has gone through, what the company has gone through. So let me focus a little bit more on some of the details and the background to illustrate, I think, how this happened and the ways in which anybody dealing with a data breach, anybody dealing with an FTC investigation can ensure that this kind of outcome is off the table and certainly not something that comes out of nowhere. There are a lot of decisions made along the way where you can take steps to ensure nothing like this would ever happen to you or to your company. So a little more detail here on the timeline. I talked about the 2014 breach. And again, we've all gone through kind of data security, cybersecurity trainings. We were talking a little bit before we got on the call about multi-factor authentication. It's remarkable how, as frustrating as that is for all of us to have to go through so many authentication procedures in the course of our day, Uber had multi-factor authentication on some of its accounts, particularly on GitHub accounts for its software developers. None of this would have happened. So as frustrating as it is to live through, it really does have a huge effect on your vulnerabilities. The 2014 breach, as I said, prompted the FTC investigation. That's now 11 years ago. Mr. Sullivan was hired in 2015. As I said, he was hired in large part to clean up the Companies Act, to bring the expertise he had from other major corporations. At this point, Uber was not a public company. He was coming from Facebook. Facebook was kind of a more mature operation. He'd been the chief security officer at Facebook, if memory serves. And so he was hired in 2015 to address and kind of corral resources and to fix the problems that the FTC had been looking at and to kind of coordinate. And he, as the trial kind of demonstrated, was involved as a public face in dealing with the FTC investigation. In the midst of the investigation, and actually sort of towards, somewhat towards the end of the investigation, Uber suffered a second data breach. Hackers gained access to Uber's GitHub account, a software development platform, who found basically passwords and login credentials to a huge store of Uber's data, all sorts of data, including data on 600,000 individuals. That I think is specifically driver's license numbers, but ultimately, I think it was 58, 59 million user records more broadly. One thing I know, Melissa mentioned as well, we get these notices all the time about data breaches. One thing we had in our mind as we were preparing for this trial is it was unclear to us, do people really still care about data privacy? Obviously, there is enough interest that there's regulatory action, there's state action, things are happening. But we didn't know going into a jury trial, is the jury really going to care about this? Do people care about this beyond the sort of niche area, beyond regulators? And I think if, one were to have time to look at the voir dire, the jury selection process, people paid a lot of attention to this. And I think the risk of exposure and the risk of a jury or a juror taking this stuff very seriously is quite high, and higher than I may have expected myself. And partially, I think being attorneys, we are more tuned to this. We see this perhaps more than most people. But I think there is a strong sense among the population that this stuff is very serious and that companies need to be attentive and cautious with individuals' private data, even if the data is not social security numbers, even if it's not bank account information. The 2014 breach here was primarily driver's license numbers. The second breach was much broader, but it had email addresses, things that you may expect a consumer to understand is out there in the world regardless. And yet even that, I think people are very worried about companies not taking care of their data. The FTC investigation was ongoing, but the FTC was not informed of this new breach when it occurred. And that is, I think, the fundamental issue. When the case was charged in 2020, I think the indictment came down. There was a lot of public attention. There was a lot of scrutiny. Mr. Sullivan is a very influential, popular mentor in that area. And I think there was a wide concern that the indictment reflected some broad new DOJ attitude, some broad new regulatory attitude to cybersecurity. We're now 5 years after the charge. There have been no other indictments like this. I don't think, having gone through it, having been there on the ground, I don't think that's the story. I don't think that's what happened. I don't think that's the lesson to draw. I think the lesson to draw is much more kind of day to day, the things that governments and prosecutors care about everywhere, which is candor. It is complying with an investigation. It's being forthright. It's not hiding the ball. Had there not been an FTC investigation open into Uber at the time, just looking at the charges in the indictment, obstruction of justice is one of the charges. That arises, at least the statute that was used in the Sullivan case, that arises when there is a pending regulatory agency investigation. Absent that, it's a very different story. And so I think one thing which showed up in the Ninth Circuit opinion as well is that I think that is a huge trigger, is transparency in the midst of an investigation. These investigations are not uncommon. As I said, a lot of young companies, young tech companies find themselves under investigation somewhere, be it the FTC, be it a state attorney general. State attorneys general are extremely active in this area now. States like New Jersey, Washington, lots of activity here. There is always an incentive, one, I think, distinctive aspect of this case and of the charges. A lot of white collar indictments focus on money. They focus on profit. They focus on fraud, taking somebody's money. That's not the story here. I think the story here, and it came up in sentencing, I think the judge was very attuned to the fact that this was not a typical white collar case. What it really was transparency. Nobody's above the law. That kind of dynamic that big companies, corporate executives don't get to have special rules applied to them compared to normal individuals who may have to comply with the subpoena. But I think also there's an element of pride that drives cases like this, that people know that admitting a mistake, admitting an issue, in 2016 when there's a huge data breach, admitting an issue is going to draw a lot of scrutiny. At the time, Melissa talked a little bit about the California regulatory apparatus today. There was one then, it was narrower, but there was a high risk that had this been disclosed to an outside attorney, to an independent actor, that they would have concluded it had to be disclosed to the users themselves, that there was a disclosure obligation at that point under state law. And obviously, if it were disclosed to the FTC, it becomes public. The FTC is not going to indulge a company's request to keep something like this quiet. It's very much in connection with their overall operation. Ultimately, when it was disclosed, so the last kind of timestamp on here, 2017, when the new CEO, Dara Khosrowshahi, did disclose it, the FTC learned, and then along with that, there were dozens of other disclosure decisions that had to be made, disclosures to state regulators, disclosure to foreign entities. So it was a huge, there's no other word than embarrassment. But had that kind of pilled and swallowed earlier, it would have been a very different story. If it had been disclosed promptly to the FTC, the obstruction angle, the obstruction concern, obviously dissipates in a way that it didn't in this case. So I see we're running close to the end there. I won't go all the way through the details, and obviously, if anybody has questions, I'm happy to talk about this. If there are particular kind of concerns in-house on how to behave, how to respond, risk factors, things that AUSAs and prosecutors may pay attention to, I'm always happy to talk about this. A few things that I wanted to flag as well, which I think may be relevant to more typical cybersecurity decisions in companies, things that I think cause some concern as in the public press about the case, but I think ultimately when one digs in are somewhat less of a cause for concern. The non-disclosure agreements played a big role in the trial, and I think a big role in the Ninth Circuit opinion that came out, and I presume with the jury. The non-disclosure agreement in this case, and NDAs are common. NDAs are not suspect by their nature, but I think when they are deployed in certain ways to a prosecutor, to a regulator, it can look a lot like hush money. It can look like witness tampering. So anytime somebody's given money and in exchange, they're saying, well, I won't tell anybody about this. Again, very common in the business world for this to happen for innumerable, perfectly legitimate reasons. In the context of a company that's under federal investigation for data security and a hacker is paid $100,000 to stay quiet about a hack, to a prosecutor and to a regulator, that looks very different. That doesn't look like a normal use of an NDA, particularly when the NDA, and this, again, was all disclosed in the trial and the subject of a lot of testimony, when the NDA didn't accurately describe what had happened. Papering deals like this, obviously, any suggestion that the paperwork itself is misrepresenting the occurrences, misrepresenting and minimizing the gravity of what happened, is going to be a blaring red light to any prosecutor, to any regulator, to the FTC, be it civil or criminal. So ensuring that the paperwork is accurate in what it's discussing is important. The payment in this case, it was the subject of a lot of attention at trial, that it was substantially more than the payment for a typical disclosure. Another kind of strong strain in this case, a strong strain in the appeal, was this bug bounty program. Again, a very common thing. A lot of companies have bug bounty programs, otherwise known as responsible disclosure programs. The idea being, if an outsider and a researcher is poking around in your system and they find an issue, they find they can get access to something that they're not supposed to have access to, if they disclose it to the company can provide some kind of a reward, some kind of a compensation. It's a totally legitimate, extremely efficient, and I think a very valuable tool that a lot of companies use. And it was a component of Mr. Sullivan's defense at the trial and a component of his appeal. The issue is, if you're going to have a program like that, you have to follow the rules of the program. Using the program as in effect, a way to kind of launder a breach, launder an attack, and make it look like it was something other than a cyber attack and a breach. The Ninth Circuit referred to it as a cover-up, and I think that's obviously what the trial theory was, what the jury seemed to accept. That as with the NDA that described it inaccurately, to treat it as a bug bounty when the bug bounty terms and conditions had certain requirements that were not met here. It was the case does not serve as an indictment in any way of bug bounty programs. They remain as valuable as they ever were, and I don't think they are suspicious, and I don't think regulators or prosecutors look at them with any suspicion. But again, and I think NDAs are the same, but if you're going to have a program and that it's tweaked to misrepresent the facts of what happened, just like if you have an NDA that's tweaked to misrepresent the facts, that's where a lot more attention starts being drawn in. The concealment aspect, obviously, when you have all of these factors coming together, and in this case they did, when you have an NDA that misrepresents the facts, when you have a bug bounty payment that exceeds the limits of the program, that appears to be when the disclosure in question appears to not comply with the bug bounty program. And then you also have within a company a cybersecurity professional not telling the general counsel of the operation, not telling anybody from outside counsel. All of these factors came together in this case to create, in our view, in the Ninth Circuit's view, the jury's view, a kind of overwhelming impression of a cover-up and an intent to deceive and withhold. All of these steps along the way could have been done very differently. Disclosing to outside counsel would have changed the dynamic. Disclosing to the general counsel would have changed the dynamic. Accurate paperwork, compliance with the terms and conditions of a bug bounty program, all would have made this play out very differently. And I think prosecutors and regulators recognize that there is an element of improvisation. I think it was Puja, or maybe Melissa was talking about incident response plans. The incident response plans, Uber had one, and that was, again, a big component of the defense. But again, if you're going to have one, strict compliance with it. It almost looks worse in some ways when you have a program and there are little tweaks and there are little kind of convenient strategic omissions or deviations from a plan that sort of seem to reflect something about the underlying intent. Again, I think that the kind of fundamental guidance and the fundamental recommendation about avoiding any outcome like this is transparency with one's attorneys, transparency with outside counsel. If there had been no hint of a concealment within the company, no hint of a concealment from the attorneys, the factual presentation is totally different. So to the extent there are people out there who have worried about this case representing some broad new vulnerability, it doesn't. I don't see that in the cases. I don't see that in the case law. But I do think it reflects the kind of old priorities of prosecutors and regulators. As I mentioned earlier, things like transparency, things like obstruction, things like cover-ups in general. Covering an attempt to kind of withhold information is always, I think, strikes a regulator as concerning. Particularly when there's an open investigation. So those are the, I think, broad strokes of, I think, the lessons from the Sullivan case. There's so many other aspects of it. We were talking earlier about different ways that companies have civil kind of exposure. This case had all of those that were in existence in 2016. There was a state AG investigation. The California led 50 state AGs into this. I think it was something like $128 million settlement. There were class actions. If this kind of a breach were to happen today, there would just be more. There are now more tools than there used to be. But I think the fundamental dynamic, the slide that was shown earlier about the kind of increase in privacy-related investigations, that spike went right up right when this case was happening. So this is, I think, it is old now in some ways, but I think it's kind of a reminder of the persistent interest, the persistent risks, and the persistent attention that regulators have, even if the particular form of the scrutiny may change over time. I think it's sort of an old story rather than a new story. I think we are now 6 minutes over. Amy, I don't know if we wanted to do time for questions. I didn't get to Solar Winds, which is an SEC story. One thing I'll say about it, which it's all publicly reported as well, for the SEC, that I think the complaint was filed in 2023. This was after the Sullivan trial. And again, the impression at the time was, oh, look, regulators are coming down much harder. Everything is changing. There are a lot more vulnerabilities to cybersecurity professionals. And there certainly have been regulatory changes, but I'll note that the SolarWinds case has been whittled down dramatically. It has not turned into a criminal case. A ton of the SEC's theories have been chipped away. The case is still there, but I don't think it represents any more of a dramatic change in the kind of underlying line attorney SEC